right, well, this past week saw a series of governorship election petition judgments. Well, aside the upset in Kano, the other states maintained status quo, so to speak. But that doesn't mean the judgments were widely accepted by all parties involved. In fact, a majority of them are heading to the higher court to seek redress. Now, one of the cases a lot of eyes were on is that of Enugu, where the court upheld the election of Governor Peter Mba of the People's Democratic Party as a winner of that March 18th election. Now, there are those who raise issues with that judgment. So let's get some more insights from a legal practitioner who joins us right here in our Lagos studio, Mr. Enibe Effiong. It's good to have you tonight.
Thank you for having me.
So there were two major petitions that were decided on, particularly for Enugu, that of the PRP and the Labour Party against the election of Governor Peter Mba. And I don't know, but for lawyers specifically, you're bound by that judgment and, of course, the generality of the public because, hey, it's based on the Constitution of Nigeria. I don't know if you've read the judgment, but if you have, over 114 pages?
145 pages.
145 pages.
Yes.
Does that put to bed some of the issues that were raised during the whole process of that tribunal up until the end? For you, that is.
No, certainly not. And I have reviewed the judgment. I have read it about 2 times, from page 1 to page 145. What makes the Enugu case one of interest is that, unlike petitions in many of the states, the Enugu petition raised issues that were germane issues that were recondite, issues that had strong constitutional flavor, and then particularly one where we saw, in not a very common way, an agency of the federal government, in this case the National Youth Service Corps, come before the tribunal, come before the court to give evidence in substantiation of the case of the petitioner, that is, in this case, the Chijioke Edoga, the candidate of the Labour Party and, of course, the Labour Party, to aid them in proof of the petition. Now, I have studied that judgment. I have tried to understand the jurisprudence of that judgment, the reasoning of my lords, and the basis upon which that judgment was given. And I say this with all sense of responsibility as the lawyer that, having read that judgment, there are several aspects of it that I have been unable to explain or that I am unable to understand. I'll give you one example. In consideration of the first issue for determination, the ground 1 of the petition, or the principal relief as it relates to the eligibility of Mr. Mba, the governor of Enugu State, or in this case, the candidate of the PDP, whether or not he had presented a forged document to INEC. The tribunal, in the judgment, considered that yes, that indeed Peter Mba had presented a certificate, an NYSC certificate to INEC. But the tribunal went ahead to say no, that because you don't need an NYSC certificate to become a governor, and because NYSC certificate is not a requirement under section 177 of the Constitution, therefore he cannot be disqualified. With proper respect to my laws, I see that as, you know, a way of giving judgment in a manner that does not reflect the spirit of the Constitution. And I will explain that to you. Now, you do not run for office simply because you have met the requirement of age, you are a member of a political party and you are sponsored by that political party, and, you know, of course, you have attained school certificate level or its equivalent, and you are a citizen of Nigeria. These are the 4 basic constitutional requirements for most political positions. But that's not all. In addition to meeting the specific qualifying requirements, a person seeking to be a governor of a state in this case must also not be inhibited by any of the inhibiting or what I call disqualifying indices under section 182. The one that is material for consideration here is that the Constitution says unequivocally that you will not be qualified to be governor of a state, or you shall be disqualified from being governor of a state if you have presented a forged certificate to INEC. So now, the question is, did Peter Mba present a certificate to INEC? In court, their lawyer said, oh, that from Isinai, right, from the the particulars of parties that he submitted, he filed, and of course the affidavits, the form that they filled, that he did not specifically mention NYSC certificate. But the question is, did you present? What is presentation? Presentation is handing over. There was no dispute. Evidence was adduced that indeed he had presented certificate to INEC. Right. And NYSC, the issuing authority came to court by their PW1 to say that this certificate did not emanate from them.
Right.
But of course, the tribunal went ahead to say, oh, that because his statement on oath, his deposition, was not front-loaded at the time of filing the petition, therefore they cannot countenance his evidence.
Let me come in here, Mr. Effiong. By the way, we also reached out to the governor's team, the legal team as well, to, of course, get some representation on this. But as of now, they're not available. But let's backtrack a bit, and this takes us back to July, during the proceedings of this tribunal. I don't know how closely you followed it. You will recall that the DSS was also present in court. Do you recall that? And this was a statement made by Mr. Mohammed, who spoke for the DSS, saying that the failure of the NYSC to maintain a proper record-keeping system was the cause of its inability to trace Mr. Mba's initial certificate, adding that it would be wrong for the NYSC to blame Mr. Mba for its own failure in record-keeping. And that was the DSS, another agent of government, as you said.
Not the SSS.
Yeah.
It was not the SSS that gave that evidence. That evidence was given by a busybody, someone who had no business even attending the tribunal. What is the business of the SSS on whether someone was issued with an NYSC certificate or not? He could not present any document that the agency for which he works had even commissioned him to carry out that investigation. And why should it be the business of the SSS to investigate allegation of forgery? Does that condescend on internal security? If Nigeria were a serious country, that official would be facing internal disciplinary procedure. Are
you saying the
the tribunal rightly, in this case, discountenanced his evidence? I, for one, saw no basis for him even coming before the tribunal. The point is this. Peter Mba had presented a certificate which he said NYSC issued him. And when you have an agency like the NYSC come to court to say we did not issue this certificate to you, I think that is evidence that should not be swept aside. Because what are we talking about? The Constitution does not say you should present, that you'll be disqualified if you present forged academic certificate, forged university certificate. It says certificate. Certificate. So having presented that certificate to INEC, I believe that the petitioner had made out their case. They had made out their case. And then you look at even other issues. What is the only sense of the NYSC? If you look at section 2 of the Act, of the NYSC Act, you are eligible for NYSC if at the time of your graduation, you were less than 30 years. And it is supposed to be compulsory. So what is the basis for asking other Nigerians to enroll in the scheme? If someone can just come out and say, this is my certificate, even though the institution says we did not issue it. But guess what? That is not the only problem that I have with the judgment of my lords. That is not the only one. There is another aspect of that judgment that I am also unable to understand. And I say that with all degree of respect to my lords, which is that in their considered judgment, in their reasoning, my lords, the three-man panel, held that the testimony of certain material witnesses who came to testify that in the collation of results at the registration area, that is the word, that what INEC imputed in Form EC8B, which is supposed to be the word collation result, was different from EC8A, which is the polling unit result. My lord said, well, that because these witnesses of Labour parties were not accredited agents of Labour Party, they cannot countenance their testimony. I had thought that the law has always been, and the court has decided in Toti and Ukpabi, that what determines admissibility primarily, it is whether the evidence is relevant. But guess what? In the new Electoral Act 2022, Section 137, the National Assembly introduced a very radical provision that where there is original or certified copies of documents before the court or tribunal that can establish non-compliance, and that non-compliance is manifest on the face of that document, you don't even need to call oral evidence.
But I find it quite interesting, Mr. Effiong, that on the one hand, you say that the testimony by the DSS official rightfully discountenanced, but for the witnesses who the court said that, well, you were not accredited agent, so we cannot take this evidence, and the court discountenanced it. Do you fault the court for doing that?
No, SSS had no business. They are not the maker of the document.
Because you say that, you also said that the DSS did not send the man, if I got you correctly.
Yes, it was established. He came on his own.
So for the agents which you talked about, were they accredited by the party?
They are members of the party.
No, were they accredited?
They were present at the polling unit.
That duty.
No, they were present. Every voter in Nigeria is an eligible witness before a tribunal.
My question is, were they accredited to perform the duty which they were meant to perform there?
The judgment says they were not accredited by INEC. But the point I am making is that, in my respectful view, the issue should have been, one, is their evidence relevant? Two, do they have a nexus with the petition? These were members of the party. And I went further to say that by virtue of section 137 of the Electoral Act, a petitioner is no longer even required to adduce oral evidence where you have certified copies or original copies of documents that can establish non-compliance. This is one provision that I'm not certain that cognizance have been given to. And I am saying that because this issue, the evidence of these witnesses, I felt, with proper respect to my lords, were relevant, the court should have looked at it. But that is not even the end of the matter.
Right.
There are certain other aspects
we have to anchor now.
I am unable to explain.
But just to paint the full picture as well, the court eventually deducted some votes
51
from the candidates, saying that 51. At least the ones that can be proven. But that's why law is interesting, the fact that you have a higher court to escalate this to, and of course we'll see how these issues played out. But thank you, Mr. Enibe Effiong, for at least providing some insight to your side, because this has been quite a big issue, really, both off and online. So thank you so much for the insights. We're speaking with Mr. Enibe Effiong, a legal practitioner on that case. Thank you for your time again.
Thank you.